Mr. Masuka, are you ready?
Yes, thank you.
Yesterday you addressed us for about 1 hour, so you've got about an hour to 1.5 hours.
Yes, I can assure your Lordship that I intend to keep myself under the hour. I do intend this morning to finalize the arguments I submitted yesterday on the issue of undue delay.
Yes.
Because as the court would have realized, we take the view that on the authorities in the Supreme Court of Appeal, you cannot go into the review unless you have gone past the extension or the condemnation issue. The court did ask me yesterday to say something about the EFF application, partly because the EFF does not bring the application under PAJA, and so it doesn't fall squarely under the limitations that PAJA provides for bringing a review application. But Lord, perhaps may I refer to the case of Mosted versus the Registrar of Pensions Funds. It's a 2018 Volume 2, SA 53. It's an SCA decision. Paragraph 34 of that judgment, the court deals with what it says the approach under PAJA to delay is not the same as under common law. And then it says under the common law, a court may refuse to hear a review if there has been an unreasonable delay in instituting proceedings. What would constitute unreasonable delay would depend on the circumstances. And then it quotes from the opposition to Urban Tolling Alliance, Justice Brandt's judgment, where he says, at common law, application of undue delay rule required a two-stage inquiry. First, whether there was an unreasonable delay, and secondly, if so, whether the delay should be, in all circumstances, be condoned. Let me perhaps dispose of the whether or not the EFF can be said to have not known about these issues that have been raised relating to Mr. Zuma's legal cost arrangement with the state. The affidavit, and here I refer to the affidavit of the EFF. Firstly, the founding affidavit is on it starts on page 7 of the EFF bundle. And you will see there that the deponent says that unless otherwise indicated, the facts in this affidavit fall within our personal knowledge. Park that, and then go further from page 22 of that affidavit, where from paragraph 31, where the deponent deals extensively with Zuma's legal fees. And you will see there that it can never be suggested that the EFF only got to know about, firstly, that there was a state arrangement to fund Zuma's legal costs, and secondly, that that arrangement dates as far back as 2006. Because if one looks at what they say in paragraph 31, they say Mr. Zuma started as following in his affidavit, handed up to Peter Marisbeck, a High Court, Msimang J, on 31 July 2006, when he opposed the NPA's postponement application and instituted his counter application for permanent stay. And then it says, as in the quotes from that 2006 affidavit, a specific consequence of the adjournment is the question of legal cost. And my Lord, you can read that paragraph. The paragraph that is really important for purposes of determining whether or not the EFF can claim to have not known about the funding arrangements is in the latter paragraph of the quotation in page 23, where it says it is appropriate to raise in this regard the current status of efforts to obtain state assistance in respect of legal costs. And then it says the President's office ultimately decides on this. In the recent past, Dr. Basson, General Malan, and others were so assisted because of their capacities as officers of the state at the time of the alleged commission of the offenses. A request for assistance was directed many months ago. The response was that the state attorney would act as the instructing attorney and fees for a specifically named senior counsel and junior would be provided. And then they go on to deal with those arrangements that involve the state. But if you go to paragraph 33 of that affidavit, you will see, if you go to paragraph 34 of that affidavit, now I have to be very quick to deal with this point. The second paragraph of paragraph 34, the second sentence, sorry, it says the only contemporaneous public record of the agreement on costs, the 2006 agreement on costs, is a newspaper 24 article dated 27 August 2006, a copy of which is attached, marked JSM4, in which the following was reported. Jacob Zuma has signed an undertaking at the instance of the state that if he is found guilty, he will pay back the money he is asking for his defense in his corruption trial. Zuma has been refusing to sign an earlier undertaking prescribed by the Office of the State Attorney, which would have the State Attorney become his instructing attorney, removing his trusted lawyer, Michael Halley. The point that we're making is that the EFF cannot claim to have not known this funding arrangement at its formation or when the EFF became representatives of the people in Parliament in 2004. So we would say they too, relying on the principle of legality, were enjoined to deal with this matter on the basis that they had delayed bringing the application to review these arrangements. Perhaps,
sorry, let me interject. But the question would also be, when did they become aware of this article?
Of what?
Of this article you are referring us to.
Yes, that they don't say, but it's clear with my lady that the article is in the public domain as far back as 2006. So that question is important, because if the deponent had said, I only became aware of this article in 2018, that set out how far this funding arrangement has been in place, that would make a difference. But you will see that in the affidavit, he doesn't make that point. And then it's important, the honourable, for the honourable to really drill down by looking at what the Supreme Court of Appeal says in Mosted, because there it sets out very clear principles that gives guidance to lower courts on how to deal with review applications of this nature, where there is clearly a delay in bringing out the application. But perhaps to close down on the issue of the EFF and the legality argument that they've submitted is the basis on which they seek to review this decision. May I refer you to the decision of Kumalo, which the EFF has relied on. It's on page 230 of the bundle of authorities that we handed up yesterday. And the paragraph that is important, amongst many other paragraphs that are reported, is the paragraph in paragraph 44, the last sentence of that paragraph, which crisply sets out the legal principle relating to reviews under the legality principle. And it says, nevertheless, it is a long-standing rule that legality review must be initiated without undue delay.
Just a minute. Paragraph 44.
Paragraph 44, and is the last but one sentence. It's the last sentence of that paragraph.
Okay. I see. Because I was looking where the paragraph starts. I can see where you're reading now.
Thank you, my Lord. So it says, nevertheless, it is a long-standing rule that a legality review must be initiated without undue delay, and that courts have the power, as part of their inherent jurisdiction, to regulate their own proceedings. To refuse a review application in the face of an undue delay in initiating proceedings, to overlook the delay. This discretion is not open-ended and must be informed by the values of the Constitution. However, because there are no express legislated time periods in which the MEC was required to bring an application, there is no requirement that a formal application for condonation needs to be brought. Now, that's very important. That said, if you want to read that judgment, you'll see that the court then goes ahead to criticize the MEC for failing to bring the review application in time and accepts that the delay had been unreasonable. Here there is clearly an unreasonable delay. And the measure for unreasonable delay has been provided, at least the guidance to determining when one can say there's been unreasonable delay. We've been given guidance through section 7.1 of PAJA, which presumes that 180 days, a period after 180 days is per se an unreasonable period, which requires a section 9 substantive application. My Lord, my ladies, let me then refer you to the case, the constitutional, sorry, the case of Oregon, the Oregon judgment, which is in page 83. I mean, the paragraph I'm referring to is in page 83, but it's also the Supreme Court of Appeal a judgment. It's in page 83, particularly paragraph 16. This dealt with the argument about when the city would have known the decision which they sought to now review. And the court says, perhaps I should just read it, the decision challenged by the city and the reasons thereof were its own and were always within its knowledge. Section 7.1 unambiguously refers to the date on which the reasons for the administrative action became known or ought reasonably to have become known to the party asking its judicial review. And then it says the plain wording of these provisions simply does not support the meaning ascribed to them by court of law, i.e., that the application must be lodged within 180 days after the party seeking review became aware that the administrative action in issue was tainted by irregularity. That interpretation would automatically entitle every aggrieved applicant to an unqualified right to institute judicial review only upon gaining knowledge that a decision or its underlying reasons, of which he or she had been aware all along, was tainted by irregularity, whenever that may be. The result is untenable, as it disregards the potential prejudice to the respondents and the public interest in the finality of administrative action decisions and the exercise of judicial functions. Contrary to the court's finding in this regard, the city far exceeded the timeframes stipulated in section 7.1 and did not launch its review proceedings within a reasonable time. So that simply disposes of this notion that somehow, both in the DA and the EFF application, somehow one must look at the date when they became aware, firstly in the DA application, of the costs that were involved. In the EFF application, of the exorbitant costs that were involved. That can be the basis on which they contend the right to bring, or the duty to bring a review application within a reasonable time kicked in. It kicked in when the decision was made. It kicked in when the EFF should have known, ought to have known what ought to have known about that decision. My Lord, that principle which I've just read in Oregon was upheld by the Constitutional Court in the decision of, again, Oregon. We have it in page 107 of our bundle, and it's on paragraph 41. That's in paragraph 41 and paragraph 42. Perhaps just also to nail the coffin on the nail on the thing on the coffin of the DA application. If one looks at the 2008 question that was asked by a DA member of Parliament, it is the same question they are asking today. How much money has the state spent on Mr. Zuma? That presupposes that they knew that the state was involved. Because if this was money paid from the personal resources of Mr. Zuma, the MP of the DA would have no business asking in 2008 the state or the relevant executive member of government to explain the amount of money that had been paid in Mr. Zuma's legal costs. And there was a little debate yesterday about which decision whether there are a series of decisions and which one are we looking at. Whichever one you look at, they all fall outside the 180 day period prescribed in Section 7. And we submit that the DA would have known this a long time ago. And of course, let me also deal with the question raised by the DJP yesterday relating to whether or not the President Ramaphosa did in fact make a decision. I have been able to find on page 22 sorry, just bear with me. I think I may have made a mistake in the yes, it's on page 68 of the EFF bundle. There.
Just a moment. Which bundle?
The EFF bundle. That's.
There are 3 volumes.
It's bundle 1. Volume 1. It's an extra JS.
Yes, I found it. Thank you.
And you'll see there
Volume 1.
that
Volume 1. Yes.
and perhaps rather it would be important to have regards to the whole letter, but what is important for purpose of answering the DJP's question relating to whether or not President Cyril Ramaphosa made a fresh decision is paragraph 2.8 on page 70. So he says, the undertaking to afford legal representation to Mr. Zuma at the state expense was communicated to him through his lawyers on more than one occasion. Due to the fact that the presidents who came after the undertaking was made, are the successor entitled in the president's office. They assume the obligation created by the undertaking. The president is therefore bound by that decision, and must continue paying for Mr. Zuma's legal fees on the basis that it undertook to do so until such time as the decision is reviewed and set aside. That does not, that would answer the question whether or not President Ramaphosa made a new decision which could save.
So it's your submission there was no fresh decision?
No, there was no
new.
fresh decision by the current president. That's it. And perhaps may I refer, just before I get off this point, in paragraph 50 to 51 of the Kumaro decision, and that's on page. That's on page 230. The judgment is on page 230, but the passage that I wish to refer to is specifically paragraph 50 to 51. The simple proposition there is that there was a duty on the EFF to explain the unreasonable delay, even if they were going under the common law approach. And you'll see that the principles set out in those 2 paragraphs answer that create that obligation on the EFF. It simply cannot come and presume that the court can exercise a discretion in favor of the review application without dealing with the fact that the review application relates to decisions made as far back as 14 years ago or 12 years ago, whichever one picks. The responsibility is to assure the courts that the review application will not upset rights of people that have been entrenched as a result of those decisions. This is where the submissions that we make on unreasonable delay end. We submit that on the authorities that we've cited, this court cannot deal with the review unless it has exercised its discretion to condone the unreasonable delay, whether it's under partia or whether it's under common law. The court must engage with that question before it does engage with the review application itself. And of course, the courts say that you've got to look at the prospects of success when one engages with that. But it's not to determine the review itself. It is to determine the question of whether or not condonation ought to be granted. Because in most of the cases do say that where there is a demonstration of egregious violation, then the courts ought to would be entitled to then say we're granting condonation for the purpose of determining the review application because the issues that are being canvassed are such that there is an egregious violation of the law. Here, there can never be a suggestion that there's been an egregious violation of the law. Firstly, because the funding decisions were always predicated on legal opinions that were obtained from state lawyers who assured the president that this decision would be legally competent. Whether they're right or wrong, that's another question. But it demonstrates that they reasonably engaged with the issues, applied themselves to the legal principles that are engaged in the decision, and came to certain conclusions that were defensible. So there can never be a suggestion that these decisions were recklessly taken, and it was just as the EFF would have us believe, that this was just a reckless and unguided exercise of power that resulted in Mr. Zuma litigating at will.
Mr. Masuku, on that point, if you look at the chronology that was presented by the EFF, if my memory serves me well, Mr. Mugagai Toby referred us to certain decisions that were taken before the legal opinion was sought. Do you remember that?
Yes, I remember the submission that he made was that the money was paid and then legal opinions were obtained after that had been done. Yes. There's just one submission I would make in that regard. What it demonstrates is not recklessness. It demonstrates a reflection. The fact that you take a decision and then you question the decision, you say, did we do the right thing? And then you engage properly by looking at whether or not you, in fact, your decision is defensible. You could criticize the state attorney for it, but it could never rise to the level at which you could say it was recklessness of the nature that the court says is egregious. Because if the state attorney, on reflection of his decision, came to the conclusion that they were wrong, and despite that conclusion, nonetheless continued to uphold their decision, then we could say, well, you yourselves came to the conclusion that this decision was wrong, but you nonetheless continued to embrace the decision and implement it as if it was correct. Mercifully, in this case, the state attorney came to the conclusion that their decisions were correct and legally defensible, and that the decisions could be implemented. So that doesn't help the EFF's argument. But let me deal with the EFF's argument on the PFMA. I'm going to come back to the arguments on the state attorney, the interpretation of the state attorney. But before perhaps I go to the PFMA argument, which I'll dispose in a moment, we have made submissions on the interpretation we promote of Section 3 of the state attorney. It's on heads of arguments. I do not propose to trouble the court with any intense legal submissions, except one or two components relating in response to what my learned friend especially for the EFF, said yesterday about the issue of cause and scope and the reference to the charges that President Zuma is facing. The PFMA argument has no merit at all. Firstly, it's not clear from the arguments whether or not the procurement of Mr. Hali should be done by the state attorney or should be done by Mr. Zuma. But obviously the PFMA would not apply if it's done by Mr. Zuma. The procurement of Mr. Hali.
Well, doesn't Mr. Zuma say it was his attorney?
I beg your pardon?
Doesn't Mr. Zuma say in his affidavit that it was indeed his attorney?
Yes, he does say that.
Yes.
But so the argument I'm making is that, so when we're exploring whether or not the PFMA argument stands, we must look at what exactly he proposes should have been the procurement method adopted, and who should have been procuring Mr. Hali for these services. But let's take the state attorney. The state attorney act. The state attorney the state attorney are government attorneys. They act for government. So where an issue involves government, state attorney steps in immediately. They don't have to go through any procurement problems. But secondly, if one looks at section 8.1 of the state attorney, and perhaps we should actually look at that. It's in the bundle, and it's on page 7. And the section 8.1 says the state attorney or the person in charge of a branch of the state attorney's office shall be entitled in the exercise of his functions, aforesaid, to instruct and employ as correspondent any attorney or other qualified person to act in any legal proceedings or matters in any place in the same way as, subject to the same rules, terms and conditions as govern attorneys in private practice, and shall be entitled to receive and recover from such correspondent the same allowance as he would be entitled to do if he were an attorney in private practice. The reason we raise that is that, well, what happens when an urgent matter requires the attention of the state attorney and the state attorney has no capacity to deal with it? The suggestion by my learned friend is that the state attorney must put out a tender, invite people to come, invite attorneys to tender, check the BEE qualifications, check all the other requirements, and then say to itself, okay, according to the scoring, we think attorneys should be appointed for this case. Meanwhile, the matter is urgent.
But Mr. Masuku, here, the section you've referred us to,
I beg your pardon, my lord?
the section you've referred us to talks about the state attorney appointing a correspondent.
Yes.
It is the state attorney that would be doing the matter. They are just appointing a post box for the address as required by the rules of the court. They are not appointing an attorney to do the whole case on their behalf.
No, my lord, they say or other qualified persons to act in any legal proceedings or matters. So it's not just limited to correspondent. But even if you were to be a correspondent,
but you know, when you look back at section 3.1, it talks about the fact that just the general interpretation, the state attorney must do all the work that can be done by an attorney.
yes.
We are clear on that. And on section 8.1, it talks about where the state attorney does not have an office and it needs to appoint a correspondent. That's how I understand it.
And if that correspondent is a private attorney, my lord, the argument as I understood it is that the state attorney, if it's a correspondent attorney, the state attorney would have to comply with certain requirements for appointing a correspondent to perform the work of government, because by law, a private attorney would not be entitled, unless appointed by the state attorney, to perform the work of
But
government.
the correspondent is just a post box.
No, no,
where
no.
they'll just receive the documents, send them back to the state attorney.
No,
And the
but
state
if-
attorney would send the documents to them for service on the other attorneys who are within the radius required by the rules.
I mean, of course, your Lordship will, I'm glad that it's a problem that you have to deal with. I make the submission that if you read Section 8 in totality, it's capable of interpretation that goes beyond simply saying a state attorney can appoint a correspondent. It's capable of that. If I'm wrong on that interpretation, then I'm wrong on it. But the submission I make in respect of these requirements that my learned friend imposes on the state attorney, that when they engage a private attorney, they ought to comply with procurement. Let me show how upset that submission is. Firstly, as I pointed out, what happens when invariably there are a number of problems. The first one being that assume the state attorney does put out a tender and 5 law firms tender for that work.
I think I understand the submission you are making. By way of example, if they are going to brief counsel, your submission is that there's no need for them that they should go by way of tender. They can just go to any counsel without a tender being published.
Yes.
That's your argument and your submission.
Thank you, my Lord. You see, you put it crisply. And then, of course, there would invariably be delays where tender system is followed, and that those delays may, in fact, result in the court being unable to resolve cases that are urgent expeditiously. And, of course, there are potential disputes that may arise from these procurement decisions and processes. Those disputes would freeze the functioning of the courts, because now you're going to be dealing with disputes between attorneys over who should have gotten this job and who shouldn't have gotten this job and who scored what and not what. And then, of course, that would create problems. Let me, perhaps my junior has just given me a good point, which I should point out. The argument about the correspondent. Let's also just remember that the correspondent attorney, the mandate for the correspondent attorney is determined by the instructing attorney. There are just no limits on what the state attorney may say to a correspondent about the nature of work that they ought to perform on its behalf when they deal with that. They're not just a postbox. That mandate goes beyond just being a postbox.
But the state attorney will be in control.
Yes, the state attorney remains in control, yes.
Whereas in this instance, the state attorney wasn't in control.
No, that is not correct. The state attorney was in control because when Mr. Harley receives invoices, he sends the state attorney for the state attorney to look at and to authorize payment. And that control is
There is not a shred of evidence that the state attorney would have obtained opinions on prospects of success before embarking on any of the ancillary litigation.
My Lord, I'll leave it up to you. The presumption I would offer the state
Now, on the
attorney.
facts before us,
No.
there
but
is
I
not,
understand it.
there is nothing to indicate that the state attorney remained in control of all the litigation. On the contrary, what the papers tell us is that there was a conflict of interest between the state attorney and Mr. Zuma's interests, and therefore another attorney was appointed. So we do not deal here with a matter where there was a correspondent attorney or any like professional person appointed.
And be that as it may, the state attorney has got an office in KZN, so there was no need that they should appoint a correspondent attorney.
Yes, the reasons why Mr. Hardy was appointed are set out in the various submissions made, I think, by the President and also by the State Attorney itself and by Mr. Zuma himself. And it relates to the conflict that would arise with the State Attorney representing the NDPP on one hand and also representing Mr. Zuma.
Yes, but that concludes that point. That means that the attorneys appointed were attorneys appointed by Mr. Zuma, as he says, and they were not attorneys that had to account to the state attorney.
No, that is not the evidence, my lord. The evidence cannot be that they do not. What do we mean when we say account?
No, I'm not
What is the
talking.
meaning
I'm
of
not
account?
talking about the accounts being rendered. I'm talking they did not obtain their instructions from the state attorney.
Yes, of course they did.
No, but that's the point.
But what's the point? Because my lord, the point is that Mr. Zuma gave his instructions to his attorney.
Yes.
So the state was not didn't have the relevant information to give to Mr. Hali.
No. But the state, what the papers tell us is that there was a conflict of interest, and therefore the state attorney could not act.
Yes. But that doesn't mean that, my lord, you conclusively say the state attorney completely had no control over how Mr. Hali performed his functions vis-a-vis.
Well,
the most
just
important
give us one single fact on the papers before us where there was any exercise of such form of control or any instructions given by the state attorney.
There is
to the
ample
state.
evidence that is Mr. Hali submitted the invoices
No,
generated his case.
that is obvious because this,
I'm glad you say it's obvious.
because the state funded it.
Yes,
So the invoices were rendered to the state attorney.
yes.
That's all.
And
But
that's very important.
there is no other evidence that the state attorney was in control of the litigation.
No, but I hope my lord is not suggesting that the funding control that the state attorney exercised is a insignificant form of control.
Mr. Masuku, did I say that?
No. But I'm making a submission that it's not insignificant.
I'm
control.
debating another point with you. I'm debating a point whether or not the appointment of Mr. Hali falls under Section 8.1 of the State Attorneys Act.
No, I never made a submission that it falls under 8.1.
Well, why did you refer us to that?
No, the argument that I was dealing with, my lord, is an argument relating to the procurement issue. And I was trying to demonstrate that the State Attorneys Act on its own provides that the state attorney may appoint a correspondent, my interpretation of Section 8, may also appoint other persons to act in a matter where the state attorney should act.
Yes,
That's
and
the point I was simply making.
yes, and then in those instances, as Section 8.1 states, in those instances, attorneys may be appointed, counsel may be appointed without having regard to the PFMA in those circumscribed circumstances.
Yes. So the point, and this was really, I think I'm in agreement with that proposition, my lord. And it goes further for me in terms of the arguments related to PFMA. I pointed out in terms of the PFMA that there are intractable problems, submitting that the appointment of Mr. Hali should have been, in fact, subjected to a procurement process in terms of which there was a whole range of controls that my learned friend for the EFF set out yesterday, which would have justified the appointment of Mr. Hali.
Very well.
That's the point. That's really the point that I was making. I was not making the point that Mr. Hali per se was appointed in terms of Section 8.1. But let me deal with the argument on the submission on the equality argument. It's not clear what exactly the argument is on the equality argument, on the equality matter. It appears that my learned friend says, on one hand, Mr. Zuma is a president, which is true. He's not an ordinary person. In fact, the EFF judgment, the EFF versus the public protector judgment in the EFF matter of Chief Justice Mukwege explains exactly what the office of the president signifies. So my learned friend is correct. Mr. Zuma was the president. He's not an ordinary litigant, and that's the point he makes. But then, when he talks about the Equality Act, he then says, well, he's not treated like us, the ordinary folks. But I mean, if the equality argument has to pass, it has to be president to president. If the argument was, there are two presidents, both facing criminal charges, one was treated better than the other, then that argument would potentially thrive. But this argument doesn't thrive at all, because my learned friend is not suggesting in his argument that Mr. Zuma has gotten preferential treatment that other state officials have not gotten. We give the example of Mr. Silebe, we give the example of Mr. Fason. Both were given state assistance on the basis that they were state officials. And there are many others, I'm sure, that with better record would demonstrate that where the state has decided that a particular official should be granted state legal assistance and the funding that goes with it, there cannot be an argument on unequal treatment in that respect. And of course, the submission that we've dealt with the submission that, well, Mr. Zuma, if he doesn't have money, he should go to the legal aid board. Well, I mean, if the concern is about public funds, legal aid board also has public funds that are being used. The simple point is that the Equality Act doesn't at all make a case for any review of the state attorney's decision. There are many reasons, my Lord, why the state attorney's position is very important, and why this facility of providing officials of government with state funding is very important. And I'm dealing now with an aspect of the argument that relates to the interpretation of Section 3 of the State Attorney Act. So one must look at what the purpose of the state attorney is: to represent government in its litigation, provide legal assistance to government. Now, any news that a judge has been charged with an offense invariably involves state interest or government interest. Why? Because of judicial independence. Because the government would say, and of course they've got to do everything they can in terms of Section 165, I think it's 4 of the Constitution, to protect the integrity of the office, the dignity of the office of the judge. So if a judge is accused of a terrible offense, which does not fall within the functions that judges are normally appointed to perform, the government interest is judicial independence. So when they provide state assistance, state legal assistance to a judge, on the control that if he should be found guilty, he'll pay the money back. Their interest is judicial independence because they're protecting the office. They're saying to themselves, look, we cannot expect the judge to pay for his or her legal costs, because if he does, we'll bankrupt him or her. And if he cannot defend himself, then how can the judge ever perform judicial functions? If he's taking from his or her own pocket, it would become quite untenable for a judge to continue serving as a judge. So the threat to judicial independence that comes from accusations that aren't tested, just accusation. You're just accused. There's no evidence yet. You're just an accused. The point that we make is that it is very important that we never diminish the value of the government interest, or the scope of government interest in protecting the offices, the officials that make the government run. So the point is that when they...
Is your point no matter what the judge is being charged with?
It's no matter what the judge is charged with.
Even if he's charged with housebreaking and theft
Even if
or
it's charged
whatever?
with rape. We say it's just an allegation.
And drunken driving?
And drunken driving. We say the state interest there is judicial independence. And remember, the control here is that if you should be found guilty, you pay the money back. But our interest as government is, well, you know, our judges are a symbol of our judicial system. They are guardians of our constitution. If they should be rendered unable to perform their judicial functions simply on allegations, or rendered unable to perform their functions because they are now required to pay from their own pockets to defend themselves from whatever allegations they face, that would not be consistent with what government should generally be doing to protect its own independence. I'm not suggesting at all an unguided sort of a view on it. There are certain instances that may well, I can't think of any now, but there may well be circumstances where the nature of the allegations is such that the government can say, no, look, I mean, we certainly do not see how government can protect this aspect.
Yeah, but Mr. Masood, I think maybe we should qualify, or you should qualify what you say. Your argument now relates to the state attorney assisting maybe a judge or a president. But in Kasu, the case that we are busy with, the state attorney did not assist Mr. Zuma with legal assistance. It was just a question of funds being paid to Mr. Hali. Is it not so?
So the real Mr. Hali wouldn't act if there were no funding. So we say the fact that the state is providing that assistance, funding assistance, is state assistance that qualifies to be regarded as the kind of assistance we're talking about. It's not private assistance. So we're saying the real issue is that but for the undertaking that the state, but for the state legal assistance in the form of funding.
I understand the issue to be that the state attorney did not, that office did not assist Mr. Zuma with legal assistance. They were just the source of the fees for Mr. Hali.
Yes, no, we understand it's similarly, my lord. I'm not suggesting anything different, but I'm submitting that in that relationship that you've just sketched, we must read that the power behind the legal assistance that Mr. Zuma is getting is the funding that he gets from the state. That Mr. Hali is able to provide legal assistance to Mr. Zuma because he's covered financially. And
so
that
the state attorney was just used as a bank to give a loan for the fees that they could recover later.
Yes, and we can call it whatever we call it, but I think my lord, in fairness, it's not an unusual facility in government.
It has happened before with
it is in fact, it happened for Yonkis of
but
years.
that does not make it right.
You will have to make that determination, my lord. I hope you have not prejudged the outcome of that question.
No, I'm listening to the arguments.
Yes.
That's why I'm raising these things to understand your submissions.
So the point really that I'm making is that the nature of government interest ought not to be simply determined by the nature of the allegations that are made. It must also be determined by the interest of government. For example, when President Zuma was deputy president, that's a constitutional office of the deputy president. I mean, it's a part of the. It's referred to in the Constitution. So,
but your point is in Section 3 of the State Attorneys Act authorizes the funding of legal costs incurred in the defense of an official such as Mr. Zuma.
That's very basic. But I would say to the court.
No, but that was the decisions taken were based on Section 3.1 or Section 3.3. The decisions to fund.
And we can't get out of it. We can't get out of that. That's what the state attorney says.
Yes.
And we can't get out of it.
Now, either that decision was correct or not.
Yes.
Either that decision was authorized by Section 3 or it was not.
And you have the arguments on that,
yes.
And
yes.
we submit that when you look at the arguments around cost and scope of employment, cost and scope of work, you do not simply look at the fact that this assistance it had to be given on the basis of a predetermination of it had to be given on the basis of a presumption of innocence. It can't be given on the basis that the state attorney must assess whether or not actually does this fall within the course and scope of the employment. But it must be based on the fact that we understand that the judge has been accused of this thing. We make no judgment on that. We're going to assist him or her on the basis that if he's found guilty, we will then recover our money. But that also helps with the cases that my learned friend referred to yesterday. The Black Sash case, where personal costs were granted against an executive member. What happened there is that the court engaged with the issues. There was evidence. The court could come to the conclusion that this was not in the course and scope of the trial because it had engaged with the evidence. And it had determined that in terms of the evidence before it, that was not the position. And then it could make a judgment. Even the cases that involve the police or whoever else, the approach would be allow the courts to make that determination of whether or not it's in the course and scope. Don't leave it to the state attorney. The state attorney can't simply decide that this is a matter that falls within the course and scope of the employment. Therefore, we're not going to fund the decision. Of course, I mean, they may well get it wrong, and I understand that there is a case where they refuse the police officer the funding of the state, but so may well have been, you can engage with the facts in that particular case and see whether or not it would be correct for the courts to impose a duty on the state attorney when they consider these matters in terms of how they understand the act itself, to make that call of whether or not they can refuse state assistance simply on the basis that they believe that this was not in the course and scope of control.
But Mr. Masuka, do you agree that the legal functions performed for Mr. Zuma in all those cases were not performed by the state attorney?
I think we've met at that
Concession.
Yeah, it's not a concession. It's a common cause.
May just assist me on this. On what basis did the state attorney fund the legal fees? Is it Section 3?
In their arguments,
yes,
that in their affidavit, my lord,
yes, it's
they
Section
rely
3.
on Section 3(1) and 3(3).
And what is your submission?
Our submission is that it is competent to rely on Section 3(1) and Section 3(3).
Yeah, but also I still do not understand that if Section 3 says the state attorney will provide legal services, how does it now change to become a funding of the legal services?
Yes, my lord, sorry, my lady, there was my little friend from the DA did attempt to actually answer how the system works. So the decision maker is the president. And you'll find that in JS6 that I referred to earlier on page 51 of volume 1 of the DA case, and it's also in the EFF case, where the president goes into detail, the Department of Justice and Constitutional Development, I think it's Correctional Services, explains exactly how the decisions are taken. So the funder is the department, is the presidency. The comfort to take that decision to fund a particular litigation involving an official in the presidency would come from advice that the state attorney gives to the department. So the state attorney would say, look, we've looked at the case. We think there is a government interest, and we would support that the department actually funds this particular litigation.
Yeah, but in this instance, I think we have already considered that what happened is that only the funding assistance was given to Mr. Zuma.
Yes.
But
So
the State Attorney's Act Section 3 says he must be provided with legal services, not funding.
no, my lady, I don't understand, because legal assistance and funding are very close cousins.
No, in the sense that the state attorney must act for the litigant, not be given money to find its own attorneys to act for him.
No. So we as I say, my lady, one must start off by looking at the purpose of establishing an attorney that acts for government. And then one then must say, how does one, so section 3.1 says the functions of the office of the state attorney and its branch shall be performance in any court of such work on behalf of government of the republic as is by law, practice, or custom performed by attorneys, notaries, and conveyancers. So we now know that the state attorney are government attorneys. They perform functions just like any other attorney in private practice, either as notaries or that.
Which do not include funding.
No, so
Those are legal functions.
So the papers do say, my lord, that the decision maker on the funding aspect was the presidency. It was not the state attorney. The state attorney recommended, gave an opinion, supported, and gave the comfort to the presidency.
No, but the decision to fund was taken on the basis of 3.1 or 3.3. This is why I put it to you. That is where the authority, whoever was the decision maker, the authority for that decision maker is alleged to have come from 3.1 or 3.3.
So,
and now we know that 3.1 authorizes the performance of legal work, usually performed by attorneys. Which
yes.
is not funding.
It does not say fund.
That's a function performed by financial institutions.
I can see the difficulty you're raising, yes, my lord, but the submission that I'm making is that the role of the state attorney as a government attorney is to advise departments on litigation that may implicate those departments or officials in that department. So when the state attorney is asked to provide legal assistance by a department, it provides that assistance. And in this case, what they did was they assured the presidency that a decision to fund a decision to fund the legal costs of Mr. Zuma was competent.
In terms of 3.1, this is what I'm debating with you. Was it competent in terms of 3.1? That's the question before us.
So my lord, it was competent. What is the state attorney doing? They are asked whether or not a matter that the presidency, that implicates the presidency, is involved in. They are asked, can we fund this particular case? The state attorney, as attorneys of government, provides a legal opinion on it to the presidency. They say, yes, you can. You can fund this particular, you can, in fact, decide to fund this particular litigation. They are competent to do it under Section 1 or Section 3. And that's what they did. So what the advice that they gave to the department was that it is competent for that department to provide legal funding or funding for litigation involving a particular official. The presidency then takes the legal opinion, reads it, and it says, okay, we conveys back to the state attorney, we can do it. We will do it. We'll provide funding cover for this particular case. So as government attorneys, the state attorney then says, okay, we'll act in the matter. In this case, it's different because the advice they get is also that they're a bit complex in this matter because the official involved sits in the presidency, yes, but and so we cannot really act in the matter because there would be conflicts because of the fact that we act for opponents of this particular individual. So how do we resolve that conflict? Get a private attorney to act for Mr. Zuma in order to cover, and that the state would cover the services of the private attorney, which would otherwise have been performed by the state attorney had the state attorney been in a position to do so. So my submission, my lord, is that we've got to interpret this act in a way that is enabling, in a way that would enable the state attorney to be effective in how they advise government, and not in a way that would restrict them. They are attorneys for all intents and purposes, like every other attorney, and they perform the work of attorneys. So when they are not able to perform because of a conflict, what do?
Let's
It's very practical.
assist me on this point, Mr. Masuk. A department is authorized to seek legal opinion and to pay their advisors separately without involving the state attorney. Is that not so?
Yes.
And in this instance, Section 3.1 says that the state attorney should do the functions of an attorney, which means, in my view, if they are expected to do what is not within the cause and scope of what an attorney can do, they should refuse to do that. For instance, a state attorney cannot be expected to come and fix the air conditions of this building.
Much as I would like them
Yes.
to do that, Madam
Yeah.
President.
But they can't. So, in this instance, because the presidency, or let me rephrase it, the presidency could have told Mr. Zuma directly that instruct your attorney and then we'll fund it, without involving the state attorney.
No. They could have done that through, because remember, the president does have his own, they have their own legal advisors. Their own legal advisors could have given that advice, but they didn't go that route. They went the route of the state attorney. That was not incompetent. Because the state attorney, when giving advice to the presidents, were exercising what attorneys generally do, give advice to their clients.
Yes, they did give advice, but why were they the people now who paid for the accounts that were sent?
No, but because the funding, the budget for that payment is ring-fenced in the presidency. So all they do is they pay from whatever budget they have, and then they claim back from the presidency the amount of money that has been paid.
Okay. May I proceed?
Okay, so I've made the point that the money comes from the presidency, and not the state attorney, which controls that budget. And why do we have this? What do the applicants tell us are the reasons why they really brought this application? If you look at both the EFF and the EA, they say we bring this application because we want accountability. State funds have been abused. Mr. Zuma is abusing the courts without a shred of evidence. I say no more than just saying it's got no basis. The allegations that the fees were exorbitant has no basis. We're not told why they believe they are exorbitant. We're simply told that, we're not even told what comparator they're using for a 15-year time frame, or a litigation that has gone either 10 years, let's put 10 years, why these fees would be exorbitant. Bearing in mind that we actually don't know the actual figure we're dealing with. We can work with what the President Ramaphosa has said, 15 million.
No, I think they said 16.5 million.
Yeah, 16.5 million. So we can work with those figures.
No, that's the only invoices they've so far received from the state attorney.
Yes. So,
But the EFF mentions a figure of 32 million.
Yeah.
So it's anywhere between 16.5 to
We
32
don't know why-
million, it seems.
we don't know why they believe that figure is exorbitant. I mean, it's exorbitant because it's 16 million here. But what is the evidence that the court can comfortably say, having looked at this evidence, we believe this was exorbitant? There's none. There's absolutely none. And perhaps yesterday I didn't answer the question your Lordship put to me relating to whether or not if Mr. Zuma had been funding his own litigation from 2008, he would have litigated as he did. Perhaps he would have.
No, we don't know, but
Yes, perhaps he would have. We all know that the litigation involving Mr. Zuma has never been frivolous litigation. It has raised issues that has engaged the courts of this country very intensely. Very intensely. It's raised very profound constitutional questions that have been answered. So the country is richer in terms of the law because of the litigation that has involved Mr. Zuma. And remember, he was not always the applicant. He was dragged in these courts, sometimes, particularly by the DA and the EFF.
But that's not the argument raised by the applicants. They're not saying the proceedings were frivolous or vexatious. They just challenging the manner in which this funding was conducted.
It's not just the funding, my lord. The point I'm making is that the basis for bringing this application is, this president, President Ramaphosa, has just told us that Mr. Zuma is going to be, is going to be supported financially by the state to defend himself. No, it's too much. Accountability demands that that particular dispensation stops. Transparency demands that this must stop. These are constitutional principles that ought to be applied in order to stop this attempt to evade justice. That's what the DA, those are the allegations they make against Mr. Zuma, that he is litigating to avoid his day in court. But of course, it's the DA. I mean, what can they say about Mr. Zuma other than to say those kind of statements? They're political statements that are intended to hurt him politically, not legally. They are not legal submissions at all. Because firstly, they don't tell us exactly in what respects this litigation can be considered to have been reckless. They don't tell us that. They don't tell us that even when a party loses a matter, it doesn't necessarily follow that they were reckless. I mean, if the DA loses this matter, it doesn't follow that they were reckless. Which I hope they do, by the way.
I'm sure you do.
Yes. So I'm saying, let us not suggest that because a party lost a matter once, twice, 3 times, however times, that it necessarily is a reflection of recklessness. The matters that involve President Zuma or former President Zuma are matters that have been recognized as having a public interest. That comes from the mouths of the DA and the EFF itself.
I think you've made that submission.
Yes. And the Supreme Court of Appeal, in one of its judgments, does acknowledge that these matters have engaged very, very profound public interest matters. I mean, of course, the DA and the EFF do say that they bring this matter in the public interest. Firstly, they bring it in their own interest, in their own political interest or legal interest. But they also say that they bring it in the public interest. So it cannot be that they are in the public interest when they are involved, but they are not in the public interest when Mr. Zuma is involved. So I would say that to the extent that you intend to go to the review route and deal with this aspect, which you say you shouldn't, this matter is clearly, or the matters in which Mr. Zuma has litigated on, clearly raised issues of public interest for which the state was entitled to look at and say, in the interest of the public, these matters do require this kind of funding dispensation. Yes. So there were submissions made by my learned friend that when Mr. Zuma became president, there may well have been a manipulation of the state attorney. There's no basis for it, and your Lordship did immediately say, but there's no evidence to that. And I hope it doesn't go further than just what the Deputy Judge President said. There is simply no evidence to suggest that there was any corruption involved between the state attorney, Mr. Zuma, Mr. Hali, and the presidency. No evidence whatsoever. And to the extent where the cases have referred to potential for a court to exercise a discretion to extend the time frames for late filing. They've said, well, sometimes matters involve corruption. And where they involve corruption, yes, the court might say, well, in these cases actually involve corruption. There are allegations of corruption that ought to be answered, and this has not been, there are not a single allegation of corruption that I could find in the papers of both the DA and the EFF. All they complain about is that, well, Mr. Zuma's litigation must be stopped because he must go and face his trial in Pietermaritzburg. But we all know that our constitution, which is the supreme law, entitles every citizen from the top to the bottom up, all of them without reference to status, whatever, to access courts. And it's very important that that point is emphasized. Because we're safe when we're in courts. We're safe because our courts are institutions of adjudicating disputes impartially, without fear or favor. They don't look at the person that is involved. They don't look at the party that is involved. They look at the issues that are involved. So they are safe platforms to adjudicate disputes. And so when Mr. Zuma is faced with problems, legal problems, and he decides to use the courts, we shouldn't assist political parties to come and scandalize that as an abuse of the right to access courts without any basis at all, with no evidence at all. So we do make this in our heads of arguments. That
are you saying if the state attorney is not going to fund anymore, Mr. Zuma's right to access the court would have been interfered with?
No.
We will address us further when we come back at 1:30.
Oh, shut up. I was hoping you finished.
Unless if you're not going to keep us for more than 5 minutes, we can listen to you.
No, I think my trainer says I must take a break. He pays my bills, so I'll finish it.
Okay. Counter Gents.
Because that's what they will come back to and say, actually. Yeah, I mean, you know that because it's a moving target about who actually makes the decisions. Because sometimes the president advises to say that sometimes the instructions.
Are we getting copies made? May I proceed, Mr. Masuku?
My Lord, I intend to take 5 minutes.
Okay, thank you.
I made the submission that the state attorney cannot decide or cannot advise a department on the funding issue based on their assessment of whether or not the nature of the allegation is in the course and scope of employment, if you recall that submission. I didn't extend that to yourselves. The submission I make is that the court is not entitled, on the papers that are before it, to make the far-reaching findings that my learned friend from the EFF wishes the court to find, that will have regards to the charge sheet, and to then conclude that this charge sheet demonstrates that these charges were not in the course and scope of employment. This court is not obviously in a position to assess the evidence that is necessary for it to come to that conclusion. I would urge this court to leave it to the Durban court or the Pretoria courts to make that determination, and then we can all be happy concluding that these allegations, which we say have no basis, are in fact allegations that are in the course and scope of employment. We stand by what we say in our heads of arguments in respect of our interpretation of Section 3. Finally, we know that this application has been brought to affect Mr. Zuma's preparation for his criminal trial. We know that because EFF wrote a letter to the state attorney or to the presidency to say that they would like to know that this funding will not be provided for Zuma when he appears in the Durban courts. So this application is intended to affect his preparation for that particular trial, because now he has to expend resources defending what he has, the current agreement that would go a great deal in helping him to defend himself in that particular trial. So, the Honorable Court must just bear in mind the safety I referred to of being here, and really accept that its constitutional role is very critical to how they see litigants and how they decide on litigants. And I say this because we do make the allegation that the EFF and the DA largely make political arguments, not legal arguments. Arguments that is reckless litigation, there's no basis for that. Arguments that there's no accountability, he litigates with abandon. Those allegations are allegations that are good at a political rally, not in this court. And because we're in this court, we are safe, because we know that the court will look at the facts and pay attention to the facts. If you make the orders that they ask you to make, they are no doubt going to be celebrated in the political rallies of the DA and the EFF. There's no doubt that in Parliament you will hear stories about how the DA has been championing the accountability ticket and ensuring that Mr. Zuma finally goes to court. Mr. Zuma wants to go to court, but he's here now, defending a facility that would help him to focus on his case. So the court mustn't be drawn, mustn't assist the DA in its political strategy and the EFF of building up a political profile by just throwing terms that are very critical for our democratic institutions, accountability, but with no basis whatsoever. That is, we submit wrong. But finally, on the authorities that we submitted, you cannot even go to the review application. It's just deal with whether or not the DA and the EFF have in fact persuaded you that there is some interest of a constitutional and legal nature that should turn things in their favor and here have the review application heard. You are bound by the Supreme Court and the Constitutional Court judgments on that issue, and would submit that it's very important that that procedure is followed, because it is a procedure that's been established as the basis of our review law. That where a party is delayed, the party must explain. It empowers the court to to engage with the issues a bit more thoroughly when a proper substantive application is brought. Here it wasn't. And so and I end with how I began. This case should have started exactly there. The question this court should ask is whether or not there is a substantive application, the basis on which it should condone the undue delay and bring these review proceedings. If it comes to the conclusion that there has been, on both the EFF and the DA, there are no applications on which the court to grant any extension or condonation, and therefore the court should not engage with the review. Would ask for costs, including costs of 2 counsel.
Before you sit down, Mr. Masuku, on the question that the preparations would be affected if we find in favor of the applicants. In one of the undertakings that were signed by Mr. Zuma, he said that he can pay the legal fees on demand. And, there's nowhere where he states that he does not have the funds. Do you agree?
Yes.
So if we rule in favor of the applicants, Mr. Zuma can still fund his legal fees, is that not?
There are 2 submissions I want to make. Firstly, the demand is not coming from the state attorney. So there hasn't been any demand from the state attorney. He has not prepared for that demand as yet. When they do make the demand, in accordance with the undertaking, they will engage each other, and the terms of the payment will be determined by that engagement. What is happening is that 2 political parties are asking you to make that determination. Mr. Zuma has put it on record that it's not going to affect his funding. Obviously affect his preparation. I'm part of his legal team. I'm here arguing a different case than preparing for the permanent stay, which we say will succeed in the Presidency court. But I'm here arguing this case. And my attorney is here arguing this case rather than focusing on that case. So we say that however you go, if you should find your way past the condemnation and you go into the review, and you come to the conclusion that the state attorney can enforce this agreement, because you don't have to make that finding actually, because that's what it is. The agreement is such that the state attorney can actually enforce the agreement at whatever time they decide to force the agreement. But obviously, if you make the determination that there's no legal authority to advise the departments to fund this litigation, then of course there are problems. But look, let's just be, and I mean not disrespect when I suggest that let's just be ordinary people. If he order that he pays on demand, that's 32 million according to the EFF, 16 million according to the GA, or as conveyed to them by the president. Just let's be ordinary. That means in the middle of preparing for his criminal trial, that's the amount he must pay, and also pay for the criminal trial itself at the time that the trial is running. So we're saying, I mean, people living in a normal environment would understand that such money is not there for the taking. And that's not to say that he has not made arrangements to pay back the money should he be asked to do so by the state attorney in accordance with the agreement. But what we're being asked here is not the state attorney coming to you and saying, please enforce this agreement. You're being asked by political parties to say that in the name of accountability and other legal reasons they've advanced, you must order that Zuma must pay 32 million or 16 million within 6 months or within whatever time that it suits them. So the repayment order that you would make would invariably affect, obviously, his defense in the sense that now he must immediately, within these next 16 months, find 32 million somewhere, pay it, and then also find some money to defend himself. And we say, obviously, you would have assisted the political parties to divert Zuma's focus on finally getting a platform, a proper, safe platform to clear his name that has been tarnished over a long period of time. And I know they will have statements to say.
Our duty here is not to assist any political party. And as a court, we will have to decide on the facts that is based before us.
I'm heartened by that, my lord.
Thank you, Mr.
Those
Masiku.
are submissions.
Thank you. Mr. Rosenberg?
Justices, this case is about decisions that were taken at the level of the presidency, in the presidency, to appoint a private legal team to represent Mr. Zuma in his criminal trial and in related litigation. And in that sense, it is a funding decision. And in that sense, in that connection, there has been reference to non-compliance with provisions, for example, of the PFMA. As to the legal or statutory basis for those decisions, the case that has been put up on behalf of the Presidency in the DA's application is quite clear. It's based full square on Section 3.1. Alternatively, for the purposes of Attorneys Act is a function provision, as the heading to that section makes clear. It deals with the circumstances under which the state attorney is to carry out its statutory function there described. And we say, and we submitted in our argument in chief, that on the basis of Liebenberg's case, 237 of the authorities bundle, once the decision has been predicated full square on specific statutory provisions, in this case Section 3.1 or Section 3.3, then the decision maker is bound by those provisions which he or she expressly declared as being the authority for the decisions in question. And we say that on that relatively narrow approach, that Section 3 is not a provision which provides authority for funding of private attorneys for a government functionary's criminal defense. The decisions may fail, must fall. We did submit that in any event, the requirements of Section 3.3, the objective requirements of Section 3.3, didn't find application, even if we were not dealing with, in fact, the funding of a private attorney or private legal assistant. We submitted, for a variety of reasons, that Section 3.1 didn't find application because the government was not concerned party. We submitted for various reasons that Section 3.3 didn't find application. Very limited argument was put up in relation to compliance with the objective requirements of Section 3.1 or the objective requirements of Section 3.3. As we understand it, the submission that appears to have been made was limited to a contention with reference to an analogy of, or an example of a judicial officer being charged with a criminal offense, and the reference or the submission appeared to be that even if it was a drunk driving offense as suggested by the bench, or even if it is an assault over the weekend at the golf club, whatever the case may be, the suggestion appeared to be that the requirements of Section 3.3 would be met, and the underlying assumption is that if you're a judge, or if you're a cabinet minister, government interests, or the public interest, particularly government interest, is automatically implicated when you are charged with any offence, no matter how unrelated that may be to the functions of the judge or the functions of the cabinet minister. And with respect, that is not what our law provides for. We know that the proper approach is to have regard as the most apposite tool for determining whether on the facts a government interest or a public interest requires state funding for the functionary concerned, that there should be a sufficient link between the government business and the interests or position of the functionary concerned, and that has generally involved an inquiry relating to the course and scope. And we've referred to Kay's case. And we made the submission, which doesn't appear to have been challenged, that on the basis of the authorities that we referred to, as a general proposition, when a police official is charged with corruption, for example, in general, unlike the case of the police officer effecting an arrest, corruption charges tend to be regarded, or acts of corruption tend to be regarded as not being performed in the course and scope of the employment. And we referred to the authorities in question. To the extent that the argument in relation to that seems to be you don't follow that approach, and the mere fact that one is dealing with a high-ranking official or functionary satisfies the government interest test or the private public interest test is in our submission clearly incorrect and an unsustainable solution. The result of that is we submit that no sustainable basis in law, no authority has been put up that would justify the decision. There might be authority elsewhere, one doesn't know. It hasn't been raised in this case. Section 3.1 and Section 3.3 has been raised in conjunction with Treasury Regulation 12.2. Treasury Regulation 12.2, on its plain meaning, has absolutely nothing to do with what we are encountering in this matter. With regard to the question of delay, the first submission is that counsel for Mr. Zuma doesn't address what we submit is the cardinal feature of the narrative in this matter which goes to delay. We submitted that on the 12th of September 2008, Advocate Sekhodi advises of an instruction to be given to the state attorney to appoint Mr. Halley and his team. So that's the September 2008 decision, and that funding decision, and that's essentially the funding decision which in the first instance is the subject of the challenge, because it's the funding decision which apparently forms the basis of the defense campaign that is going to be launched on behalf of Mr. Zuma going forward in relation to his re-indictment. But shortly after the funding decision of late September 2008, the prosecution was discontinued. April 2009, the prosecution was discontinued. And from that point onwards, effectively, the question of funding for Mr. Zuma's prosecution became, for all effective purposes, moot and no longer an issue of particular ongoing import and consideration. Now, of course, at that time, of course, the DA and the other applicant, the EFF, had no idea of the decisions, what decisions had been taken, when, and for what purpose. Other than at about the same time, in fact, shortly before the funding decision of 2008 was taken, there was the very unhelpful exchange, both in regard to a rather broadly framed parliamentary question and the response to that, which went to the question as to what provision has been made for the recovery of any costs incurred.
But the DA knew about the decision and they could have requested further information regarding the decision.
Yes. In 2008, at the time that the parliamentary request or question was submitted, it may be accepted from the answer that the state had, and it may be inferred from that answer, that the state had paid certain costs in relation to Mr. Zuma's defense. That may be accepted. It didn't know the basis, when a decision had been made, by whom, and the detail of that decision. And the submission is that at that time, the question then is, post-September 2008, to what extent is there would it be reasonable, or is there an obligation to try and find out details of whatever decision had been made to fund Mr. Zuma's litigation defense? The reason why we submit that it wasn't reasonably to be expected of anybody to pursue details of, or to try and obtain details of the decision, who had made it, when it had been made, is because the criminal charge was withdrawn at that stage. That, we submit, is a very significant feature. The criminal charges, or the re-indictment, takes place 9 years later, in March of this year. And the question which then has to be decided is, was there a lapse of a reasonable time between the decision which is relied upon as the funding decision going forward? We've made the point that as to the decision in question, it has emerged in the papers, in the explanatory affidavit filed on behalf of the Presidency, that ultimately it was the September 2008 funding decision which was regarded as being a decision which continued to operate. And in those circumstances, the question would then arise as to, was the lapse of time reasonable or unreasonable in the circumstances? And if I could just flag one issue here, because I'm going to come back to it, or perhaps I could profitably deal with it now. The question of whether there has been an unreasonable lapse of time and whether condemnation is required in the interests of justice only requires to be addressed if it is found that on its terms the funding decision of September 2008 continues to be of application to the funding of Mr. Zuma's defence from March 2018 going forward. The court has our submissions that the funding that was undertaken and assented to in September 2008 was for a different team, in different circumstances, for different tariffs. It was never intended to be funding for a re-indicted criminal proceeding some 9 years later. No submissions were addressed on that contention.
But the DA knew from 2009 until the charges were reinstated that Mr. Zuma was represented by Mr. Hali, and then that the proceedings were funded by the state attorney.
Yes.
In that 9 years.
Now, I will go back to deal with, in a moment, the question of whether that lapse of time was reasonable or unreasonable, because that's the inquiry that has to be made. And in that regard, it's not just a question of 9 years, it's a question of the lapse of time in the particular circumstances, having regard to the facts as a whole. But the point that I'm making, and I have made, and I'm going to move on from that, is that if the court should find that the decision to fund, which is relied upon by the Presidency in September 2008, doesn't find application to the question of further funding in 2018, then the question of reviewing that decision doesn't in the first instance apply. Insofar as the narrower question then is Mr. Zuma entitled to funding going forward? And the Presidency has said in that regard, it adopts the approach that the September 2008 agreement is extant and fit for purpose. We've made the submission in that regard that there is no ongoing extant agreement in relation to funding going forward. But that doesn't deal, that's obviously just a confined aspect of the matter, but it's an issue which nonetheless requires to be addressed. And it's an issue which would require...
But the relief you seek also concerned the period prior to 2008.
Of course, I accept that. That's why in the first instance, that is a submission that is confined. We accept that. But the relief that's sought goes beyond that. And that's why I'll return now to the question of the lapse of time. And in relation to the issue of the lapse of time, the Promotion of Administrative Justice Act, in section 7(1)(b), provides for the institution of proceedings within 180 days of the time from which the applicant or the person concerned becomes aware of the decision and the reasons for it, or might reasonably be expected to have become aware of the action and the decision. So it's a question of from what time might a person reasonably be expected to have become aware of the decision. And in those circumstances, that inquiry requires an evaluation of all the facts and circumstances. If one could perhaps for convenience refer to Kamalo's case, which was dealing with, which is at page 230 of the bundle of authorities, and that of course is dealing with the question of the common law test, the two-stage test for determining, one, whether the period is reasonable or unreasonable. It's an objective inquiry. And thereafter, for determining whether, well, that's a factual inquiry, and thereafter, exercising a value judgment in the circumstances of the particular case. And that's at paragraph 49, where the court endorsed the decision of the majority in the Supreme Court of Appeal that an assessment of the question of undue delay, paragraph page 235 of the bundle, involves examining whether the delay is reasonable or undue, a factual inquiry upon which a value judgment is made in the light of all reasonable circumstances. And then, if on the basis of that factual requirement, it's concluded that the delay was unreasonable, then the court, in the exercise of its discretion, is entitled to overlook the delay and nonetheless entertain the application. So the question whether or not the delay in challenging the operative decision, because that's the first question, the operative decision was taken to fund in September 2008, whether that delay was reasonable or unreasonable in the circumstances. And we've submitted that this court should find that in the particular prevailing circumstances, that delay was not unreasonable, because in the circumstances of this matter, we know that each time the prosecution was withdrawn, for example, in September 2006, a subsequent decision then has to be made for funding going forward if and when the matter proceeds. In this case, after the withdrawal of the decision to the reversal of the decision to prosecute, in those circumstances, from early 2009, there was no need to find out or to investigate the decision and the reasons for the decision. And the question then is, when should the applicant reasonably have become aware of the decision and the reasons for it? And our submission is, in those circumstances, it would have been unreasonable to expect that the DA in this matter would have sought to challenge and hence find out the basis of any decision of which it was unaware at that stage to fund the criminal defense of a case which was not proceeding. And it became a matter of considerable public import 9 years later, because 9 years later there was now not only the knowledge of how the matter had played itself out from 2005 to date, but also the fact that the narrative, the playbook was about to start afresh. From March 2018, the clock had been rewound, and there's every prospect, given what Mr. Zuma's defense team indicated his intention was when the Supreme Court of Appeal heard the DA review, that much of the strategy, the defense strategy, which had been employed over the preceding years, was going to be employed again. And we've heard as much from counsel for Mr. Zuma as to what the first planned step in that campaign is. And that is why it then became a matter in the light of the re-indictment of pressing public concern. So our submission in that regard is that the delay was not unreasonable. If the court is of the view that in the circumstances the delay was unreasonable, it's then a question of condemnation of that and whether in fact there are public interest requirements or considerations which have a bearing on that. And I would submit that there are compelling reasons that this court should exercise its discretion. We deal with those in paragraphs 97 of our heads. And with respect, it doesn't appear to us that those particular public interest considerations, which we say are compelling, have been addressed in argument on behalf of Zuma. We submitted that the matter was one where the interests of justice overwhelmingly favour granting the extension. Perhaps I could ask you to turn to page 45 of our heads. There's been so much paper in this matter that one is inclined to resist going to the sections in question. But if you were to have regard to paragraphs 97 of our heads at page 45, we make the point that the interests of justice overwhelmingly favour the granting of the extension. The matter is of obvious public importance, not only because of the sums of money involved, but in fact more compellingly because of the issues that it raises. The issue of state functionaries seeking state legal assistance in the context of corruption charges is of obvious public interest, particularly at the time that we live in, whether it's in the wake of the state capture report or investigation. The issue of the circumstances under which government functionaries facing corruption charges are entitled to legal assistance at state expense, and not only the state attorney, but private legal assistance, cries out for consideration by this court. So that is the first, and what we submit, a compelling public interest factor. Secondly, we've submitted that the state is continuing to pay Mr. Zuma's interest and that it will continue to do so. We've made the point that one can look at in the rear view mirror and see clearly what has occurred in this matter, and we would invite the court, if necessary, to have regard to the comments, and I'm not going to read them to the court, that the Supreme Court of Appeal made in relation in the judgment where it ultimately set aside the decision to withdraw the charges by the acting NDPP, to the account by the Supreme Court of Appeal of the manner in which and the duration over which the criminal charges and related litigation have been handled. And we say it is in the public interest that questions of unlimited state funding as a device to enable luxurious and never-ending litigation, the recurring end of the never-ending, I think Navsa J. referred to it, is an issue that calls for determination by the court.
I would like to remind you that in our discussion we said the reply should not take more than 30 minutes. We're left with about 3-4 minutes.
As the court please. And in paragraph 97.4 and onwards, we deal further with related aspects of the same point. So, in those circumstances, we submit that on the delay issue, the period of time was not unreasonable. The court should find that. If it was or is to be construed as unreasonable, and it is to be contended that in fact, notwithstanding what I've indicated, parties should have instituted further investigations to try and find out what they didn't know. It's common cause that the parties didn't know what particular decision had been made and when and what the ambit was. We submit that the public interest considerations require intervention. If I could just conclude with dealing with the terms of the proposed order that we submit should be made. If I may hand up a copy of the draft that we prepared for the court's consideration. The amended notice of motion is at record volume 1, page 64. And the relief or remedy that is sought is essentially for a setting aside, for the reasons we've given, of all of the decisions to provide legal assistance or to fund legal assistance. And related to that, we've sought and continue to seek the necessary declarator that we provided for in paragraphs 1 and 2 of our original notice of motion. If I could, before directing your attention to the provisions of the draft order, deal with one aspect, and that is the question of repayment. The approach that has been adopted in the DA application is that essentially Mr. Zuma is the beneficiary of the payments that have been made. He has received the benefit of the legal assistance. It's legal assistance which presumably he would have sought and paid for anyway. This is directed not so much at getting his legal team to disgorge or repay what they've received. It is appropriate remedial relief addressed at the beneficiary, and that is Mr. Zuma. And for that reason, we submit any repayment order is on the basis that Mr. Zuma, as the beneficiary, must be the party who repays. We've made provision in the draft order in paragraph 1 for the declarator in question, and this is a draft order which, as I understand it, has been prepared to serve as a draft order in both applications. It may be that in the course of debate with counsel for the EFF certain deviations might emerge, but speaking from the perspective of the DA, paragraphs 1, 2, and 3 go to the declarator, and he's setting aside which we've sought in the amended notice of motion. As far as the repayment is concerned, we've refined that provision, whereas in paragraph 4 of the original notice of motion at page 65, we have just provided for an order that Mr. Zuma be directed to repay to the National Treasury any and all such amounts that have been paid, in the light of the difficulties which have been thrown up as to the amounts in question, and in order to facilitate clarification of those amounts, we've provided for an order where the State Attorney, who is a party to these proceedings, and who was the conduit who made the payments on behalf of Mr. Zuma, and presumably recorded those payments and is in a position to collect detail of those payments, we've made provision in the order for the State Attorney to provide an accounting of those payments as a necessary first step to give meaning and content to a repayment order. And then in 4.2, we provided for the State Attorney to take necessary steps, including the institution of legal proceedings, to recover the amounts paid by the state to Mr. Zuma, for Mr. Zuma's benefit. Those are the submissions.
Paragraph 6. Why costs against the first to fourth respondents? They are not even opposing this application.
Your Lordship is quite correct. As far as the DA is concerned, that is an issue which has been introduced into the order and reflects essentially the EFF's.
No, the EFF is 29. EFF is number 7.
Yes.
And they only seek costs, or it only seeks costs.
Your Lordship is quite correct that in the DA application, the costs that initially were sought in the notice of motion.
Yeah, but I'm talking about the draft order that you've handed up.
Yes.
Now in paragraph 6 thereof,
Yes.
cost in the DA application is also sought against the first to fourth respondents.
Yes, it should be the first to the second respondents. We will make
No, but
provisions.
they are not opposing the application.
Well, effectively the presidency, costs were sought against the presidency in the notice of motion, which is not necessarily confined to circumstances whether the presidency opposed or not. Costs that were originally sought were against the first respondent and against the fourth respondent.
So in other words, you persist with that.
We persist with the order for costs against the first respondent and the fourth respondent. And I will make the necessary adjustment to address that particular error in paragraph 6.
So it should be first and fourth.
First and fourth respondent.
Yes.
As a group.
Thank you. Mr. Muraichori,
So, of course, we'll grant you the indulgence to address from here.
do you have microphones there?
There is a microphone.
Oh, okay, yes.
Thank you. Let me start with delay. I want to make two submissions of delay. The first is in reference to the Kumalo judgment of the Constitutional Court. My understanding, my learned friend will correct me if I'm wrong, was that he says that we were under a duty to apply for condemnation, even though we brought a legality challenge. This point is answered authoritatively in paragraph 44 of Kumalo, where the majority judgment says, nevertheless, it is a long-standing rule that a legality review must be initiated without undue delay, and that courts have the power, as part of their inherent jurisdiction, to regulate their own proceedings, to refuse a review application in the face of an undue delay, or to overlook the delay. This discretion is not open-ended and must be informed by the values of the Constitution. And then it says, and this is the important line, however, because there are no express legislated time periods in which the MEC was required to bring the application, there is no requirement that a formal application for condonation needs to have been brought. So the second argument on delay, in addition to the submissions made by Mr. Rosenberg around the public interest, what takes this case outside the norm is the concept of a continuous wrong. It is true that the first decision to find Mr. Zuma was made in 2006. It is true that the second decision was made in 2008. But the wrong that began in 2008 is continuous. Every time counsel is briefed, every time an attorney is engaged, every time an invoice is submitted, that wrong is continuous. This is precisely the finding in the Barnett judgment, the paragraph 20 and 21. There's just been no engagement with that principle.
That's the judgment that you referred us to when you addressed us in chief.
Indeed. And briefly the facts were...
By Brand J.A. in the SCA.
By Justice
Yes.
Brand. Yes. Land was occupied, the government comes to court 4 years
Yes,
after the
I can recall that fact.
The occupiers say, sorry, your claim is prescribed. The SCA says, as long as that wrong that began 4 years ago is continuous, you are not out of time. And this is why this case is outside the norm of a review that's granted, frozen in time. And again, there has been no engagement with that principle. So on those two grounds, and we know, if I may add a third ground, but I made the point in my original submissions, we know that Mr. Ramaphosa says he will continue funding to the future. We know that Mr. Zuma, in his answering affidavit, expects funding to the future. So not only is there a continuous wrong, even for the future, they will continue funding. The only thing that will stop them from continuing this funding is a judgment by this court. So the delay point is a non-point. And unlike the DA, in paragraph 2 of the notice of motion of the EFF, we specifically challenge each decision to pay. Again, you had no submissions at all about why each decision to pay is itself time-barred. And the most recent events took place in March 2018. They even tell us, subsequent to March 2018, we are still going to challenge the application. We are still going to challenge the decision by Mr. Sean Abrahams to reinstate the charges against Mr. Zuma. So we would submit with respect the delay point can be disposed on the simple principle of a continuous wrong. The second argument I want to make and reply is around the PFMA. Your Lordships will recall the complaint by my learned friend that the PFMA has no application, and in fact it would be impractical to apply. How the PFMA came into the equation was in the answering affidavit by the state attorney. And that answering affidavit is at volume 2 of the EFF binder. When they explain why they took the decision, they invoke section 3.1 and 3.2, but also at page 89 of volume 2, paragraph 7.1. This is what they say. The aforesaid provisions are further galvanized by the Public Finance Management Act, and then they quote section 3 of that act. And then later on, at page 91, they summarize in paragraph 9. The aforementioned provisions of the State Attorney Act read with the PFMA and the Treasury regulations entitle members of cabinet or state employees who are liable for acts committed in the course and scope of their employment to legal assistance at the instance of the state. So it is the decision maker, the state attorney, who comes to court and says that I have authority, A, from the State Attorney's Act and from the PFMA. We say in response, if the source of your authority is the PFMA, quite independently from the State Attorney's Act, if your source of authority is the PFMA, it also prescribes a procedure. And the PFMA complaint is twofold. One is, what procedure did you follow when you engaged the services of Mr. Hadi? We know on the facts that they followed no procedure whatsoever. The second aspect of the PFMA is financial controls that are prescribed in section 38. In relation to that, there is plenty of evidence on this record that initially, certainly in 2007, it was intended that because of the expenditure of public funds, there would be constraints on the funding and there would be constraints on how the money is spent. So we argue that A, in relation to the PFMA, which the state attorney claims to have relied upon, they never followed any procedure. Secondly, we say they failed to exercise financial controls. And the failure to exercise financial controls can be illustrated. One, they appointed a private attorney, and we know that under the State Attorney Act, they are not entitled to appoint a private attorney. The state attorney himself must perform the functions. Number two, when they engaged the private attorney, they did so without any advice being obtained. Then the judge presiding put the question to Mr. Masuku, he couldn't answer the question because on the fence it's incontrovertible. Number three, Mr. Zuma was funded for the watching brief in the shade trial, way before all this began. Number four, if one looks at the DA record in relation to the Leveson judgment, Mr. Zuma was specifically told that we are funding you on the basis that if you fail, you will pay. That was in 2007. We are sitting in 2018. The state attorney made no attempts to exercise the financial controls imposed by the PFMA. Number six, we know that there was never any decision that Mr. Zuma would be funded for an adverse cost order. But we know in this case that the adverse cost orders against him were funded by the state. It's completely unauthorized expenditure. And it's completely wasteful expenditure. Both of those concepts, an unauthorized expenditure, an irregular expenditure, and a wasteful expenditure, are Section 38 concepts of the PFMA. Number seven, we also know that in relation to the Nicholson judgment, which was the interlocutory application, it was also granted in 2008 on the basis that if Mr. Zuma fails, he will repay. 10 years later, there has been no attempt by the state attorney to recover the money. So those 8 indicators simply show that there has been a gross mismanagement of the funds in this case. All of the checks and balances in the PFMA in relation to financial controls were not complied with. So we say in sum, 1, no procedure was followed to appoint, and 2, there was no prudent financial management as prescribed. So their reliance on the PFMA actually doesn't help. What we know is that they violated the PFMA. And there are material consequences to this failure. If you take the 2007 decision, where they said, we will pay you, but if you fail, you must repay us. If they were to claim the money tomorrow, as we are proposing in the draft order, that claim most likely has prescribed. The same way as the claim in relation to the Nicholson judgment. If they instituted tomorrow, that claim most likely has prescribed, which means the public has been left out of pocket by the pure mismanagement and negligence of the state attorney. The fourth argument relates to Section 8.1. The Lordship presiding, I think, put the question. It's clear that Section 8.1 of the State Attorneys Act is not a section that authorizes the appointment of the private attorney. It is a section that authorizes the appointment of a correspondent. Number 5, Section 3.3 has been argued substantially by the DA. We want to add only 3 aspects to it. Section 3.3 does 2 things. The first is that it sets out the authority test. In other words, who must provide the legal services? On the authority test, the services must be provided by the state attorney. The second element of Section 3.3 is to set out the substantive test. Under what circumstances will those services be rendered? This particular request by Mr. Zuma fails on both aspects of Section 3.3. It is not done by the state attorney, it is outsourced to Mr. Hali. But secondly, on the substantive question of cost and scope, it completely fails. It was interesting to listen to my learned friend make his submissions around the cost and scope concept, because even he could not justify the cost and scope argument by reference to the indictment, because the indictment clearly takes Mr. Zuma outside of cost and scope. In fact, it takes him in direct collision with cost and scope. And hence, the best argument that could be mounted is that no, the court shouldn't decide the cost and scope. It should wait until the criminal trial is finalized. But of course, the argument cannot work. The criminal trial is not deciding cost and scope, it's deciding guilt or otherwise. The funding decision has been made now And it was made on the basis of cost and scope. There is now a review based on the cost and scope. If it cannot be sustained on the basis of cost and scope, it should simply be set aside. So it's illegal, not only for the PFMA reasons, it's illegal also because it fails the test. Firstly, the test of authority under Section 3.3, also the substantive test of cost and scope. And finally, this case really is no different from the Nkandla judgment. What we are dealing with here is a president who has been enriched at the expense of the nation by the public. This is the same scenario that is governed by Section 96 of the Constitution. The Constitutional Court in the Nkandla judgment, paragraphs 8 and 9, that I would recommend the court to have regard to, explains the entire concept of a conflict of interest. And this is what is said there. In paragraph 8, the public protector's finding on the violation of Section 96 was based on the self-evident reality that the features identified as unrelated to the security of the president, checked against the list of what the South African Police Service security experts had themselves determined to be secure, were installed because the people involved knew they were dealing with the president. When some government functionaries find themselves in that position, the inclination to want to please higher authority by doing more than is reasonably required or legally permissible, or to accede to a gentle nudge by overzealous and ambitious senior officials to do a little wrong here and there may be irresistible. A person in the position of the president should be alive to this reality and must guard against its eventuation. Failure to do this may constitute an infringement of this provision. There is thus, paragraph 9, a direct connection between the position of the president and the reasonable foreseeable ease with which the specified non-security features asked for or not were installed at the private residence. This naturally extends to the undue enrichment. The president must have known when these payments were made that he was benefiting himself in his personal capacity and not in his official capacity. Nevertheless, he allowed the conflict to fester. And that is why this court, whether it is on condemnation or on the merits, has to grant an order that is effective enough to make sure that he replaces the money. I have no further submissions.
Is that the draft order that was handed up? Is that the proposal of both the DA and the EFF?
Reluctantly, yes. If it were according to the EFF, he would pay back the money tomorrow.
Yes.
But we accept that it must be on the basis of a civil summons.
Yes.
And
I think we should not repeat the mistake that was made in the directive. The case number on paragraph 7
Oh, yes.
is 29984.
My Lord, my case number is 29984/18.
Yes. But in the draft order, it's 29484. The mistake that was made in the directive.
I have Mr. Rosenberg's juniors to blame for that.
Okay. 29984.
All right. I think, my Lord, I am the one making the mistake. It looks like it's 29484/18.
The right case number is 29984/18.
No, I'm being confused by the DA there. the correct case number is 29984/18.
Yes.
That is my case number.
Mr. Mabena, do you want to make a submission?
Yes, my Lord.
I know for sure that the first and the previous students have not filed as an affidavit and indicated that they abide by the decisions court as early as unit after use of motion was set up on them. I'm talking about the question of cost. So I know that under the circumstances, I'm not supposed to partake in the proceedings, to do submissions on the basis that no papers were filed before this court. But the question of cost were not. We submitted that if I'm permitted to tell only to my submission, the question of costs, we submit that
the first and the fourth respondent should not be subjected to that because they have indicated their rights from the inception of the period. So I submit that it should not be allowed for whatever reason. Unless you're looking for that. I know I'm not supposed to be here, but I'm here.
Okay, we heard you. Mr. Anwar, I told you, I don't want any confusion later. In your notice of motion, okay, in your papers,
Yes,
the first respondent is the state attorney. And on the draft, you seek that cost be paid by the first respondent, and we should not make any cost against the second respondent.
No, in our notice of motion, the state attorney is first respondent,
Yes.
and Mr. Zuma is second respondent.
Yes.
And
In the draft,
in
the draft order that has been presented to us.
Paragraph 7 of the draft order.
And, okay, I need a copy.
We're going to blame the DA again.
No, we're not. The intention is that they must be paid by Mr. Zuma, his second respondent.
So that's the
And
intention.
that's consistent with
Yeah.
paragraph 4 of our notice of motion.
Okay.
And I wonder if the court has corrected case number. It's not 294, it's 299.
Yes, yeah, that has been corrected.
Justices, we also want to make sure that there's no confusion, and I just want to clarify to the extent that it hasn't been clarified, and we will amend the paragraph where our costs are sought for the DA. Costs have since the outset and continue to be sought against the first respondent, the President, and the fifth respondent, Mr. Zuma.
Yes.
Those are the costs that the DA seeks. And we will amend the paragraph that caused the confusion.
Mr. Rosenberg, let me understand you. First and fifth only, not fourth.
Yes, first and fifth only. From the outset it has been, and I'm sorry for the confusion in the draft order, it has always been the case that the cost should be paid by the President and Mr. Zuma.
Thank you. Would like, on behalf of my colleagues, would like to thank all counsel for detailed and very informative arguments that were made, which we think they will help us as we prepare the judgment. We're going to postpone the matter sine die for the judgment, and we'll try by all means to let this judgment be delivered before the end of this term. Court adjourns.
Ha ha!